You've been served with a restraining order. Well, what does that mean? A restraining order, or more commonly known in Indiana as a protective order, is a court order that prevents someone from contacting another person. Now that's physical contact, but also contact over the phone, over social media. It's any contact whatsoever. Restraining orders are civil in nature and not criminal, although if you violate a restraining order, they can lead to criminal charges. At its basic, a restraining order is put into place to protect another party from either domestic violence, multiple acts of harassment, or stalking. And those are basically the three different types of protective orders. If you're petitioning for a domestic violence protective order, then you must show to the judge that a family or household member has either put you in harm or placed you in fear that harm would be coming your way. Now, a family or household member is going to be a spouse, a child, a relative, anyone living with you, a former or ex-boyfriend. Basically, anyone that is your family or you've had an intimate relationship with would qualify as a family or household member for the domestic violence portion of a protective order under Indiana law. But there's other ways that someone that is not a family or household member can also get a petition in front of a judge for a protective order, and that is with harassment or stalking. Stalking is defined by Indiana Code as a knowing or intentional course of conduct involving repeated or continuing harassment of another person that would cause a reasonable person to feel terrorized, frightened, intimidated, or threatened, and that it actually causes that victim to feel terrorized, frightened, intimidated, or threatened. So what that means is that you're doing something to a person that is placing them in fear, but the standard is what a reasonable person would do. So if you're walking down the street and you pass by someone and they freak out and want to file a protective order for stalking, that's not going to cut it, because a reasonable person in that situation is not going to feel frightened and threatened by you just by simply walking down the street. Now, harassment under Indiana law means conduct directed towards the victim that includes, but is not limited to, repeated, continuing, impermissible acts that would cause a reasonable person to suffer emotional distress and actually causes that person to suffer emotional distress. Indiana law has defined repeated conduct as 2 or more incidences. Typically what we see when a protective order is filed under harassment is someone calling someone multiple times a day with no legitimate reason to do so, spamming their inbox in emails, going on social media, constantly posting about a person, calling them out on Facebook, things of that nature. But it could also be in-person contact, driving by someone's house every day, waiting for them at their place of employment, things of that nature. But the big thing here is it has to be 2 or more acts. If you call someone a couple times on one day, that's not going to rise to the level of needing a protective order for repeated acts of harassment. If you've been served with a protective order, please give us at the Marc Lopez Law Firm a phone call. I know we can help. Our number is 317-632-3642, and always remember, plead the fifth.